It is an honor to share some thoughts today on the Ontario Human Rights Commission's experience and work on racial profiling, which you refer to as ethnic profiling. I will share some of the work we've done, particularly in policing, and the lessons learned that could apply in Europe and potentially in other parts of the world. We know that in Europe, the key factors driving racial or ethnic profiling include concerns over terrorism and the movement of migrants and refugees. In Ontario, with a population of just over 14 million people and a province that combines large urban centers and small remote communities, we face some of the same issues, especially relating to the profiling of Muslim people. And we regularly grapple with the influx of people from various ethnic backgrounds, from Jewish refugees in the mid-20th century to Syrian refugees today. In a country known for its immigration, almost 3 in 10 residents identify as a visible minority. But there's more to Ontario's story. Racial profiling here has its roots in a past that includes colonialism and slavery, and which manifests to this day in the racial profiling of Indigenous and Black people. Racial profiling in Ontario has existed for decades, and it continues to cause harm to families and communities, and unfortunately, the harmful effects are often intergenerational. Systemic racism in policing has a profound negative effect on individuals, their families, and entire communities. And this is a particularly problematic aspect of racial discrimination. Racial profiling occurs when, for reasons of safety, security, or public protection, people are subjected to greater scrutiny based on things like the color of their skin, their ancestry, or their religion. This is a human rights issue because marginalized and vulnerable people bear the brunt of over-policing and its negative consequences, and these are the very communities that human rights legislation is meant to protect. Racial profiling also undermines trust in public institutions, and ultimately it undermines public safety. And yet, the institutions empowered by the state to enforce the law often deny, minimize, or fail to take steps to meaningfully address it. The Commission has been working to eradicate racial profiling for almost 2 decades. In 2003, we released Paying the Price, the Human Cost of Racial Profiling, a report on our first public inquiry into racial profiling. Paying the Price drew on over 400 personal accounts of racial profiling. It looked at the human cost of racial profiling on individuals, their families, and their communities, and the detrimental impact of this practice on society as a whole. The report included many recommendations, beginning with something as basic as having organizations and institutions accept and acknowledge the reality of racial profiling and the need to address it. 15 years ago, Paying the Price caused a public firestorm, and the Commission was roundly vilified by police leaders who denied that racial profiling even existed. So, back then, we knew we had a lot more work to do. After Paying the Price, we discussed racial profiling in our policy and guidelines on racism and racial discrimination, released in 2005. We challenged the government and individual police services to revise or simply abandon the practice of street checks. A street check, also called carding, is when an officer interacts with community members in a non-arrest scenario for the purposes of asking and obtaining identification, personal information, or further information about the individual's circumstances. Long and short, it's the Canadian version of the stop and frisk practices so common in the United States. In Ontario, data showed that a disproportionate number of Black, Brown, and Indigenous youth were routinely being stopped by police. Our work on street checks was part of a larger community effort that led to major changes to the Provincial Police Services Act in this past year. We also intervened in several cases before the Human Rights Tribunal of Ontario, where racialized people alleged that they were subjected to extra scrutiny based at least in part on the color of their skin. And we're working to create policies and guidance for police and other organizations to identify and remove racial discrimination and profiling from their operations. Over time, we've developed a clearer picture of racial profiling as a unique type of racism, and one that the average Indigenous, racialized, or Muslim person in Canada experiences all too often. But even today, there is a strong resistance to naming racial profiling, even when the proof exists. One example involves the Ottawa Police Service. This police service responsible for policing Canada's capital city of approximately 1.2 million people, including a large Middle Eastern and Somali population. In a 2012 settlement between the Ottawa Police Services Board and the Ontario Human Rights Commission in the racial profiling case of Chad Aiken, the police agreed to collect race-based data on traffic stops. The result was Canada's most comprehensive police data collection initiative. University researchers who analyzed the data found that Black and Middle Eastern people were stopped by police at disproportionate rates. After the findings were released, the Commission noted that the data was consistent with racial profiling. It seemed obvious, especially when we considered the context for the data collection project itself, the lived experience of Chad Aiken and many other people like him. That's why the Commission and the community were very disappointed when the Ottawa Police announced that the findings did not prove racial profiling. Despite the ongoing challenges and sometimes outright denials, there seems to be a growing consensus among Ontarians that distrust of police is at a crisis point and that racial profiling is one of the factors affecting public confidence in law enforcement. In May 2017, we completed an extensive research and community consultation project to see how far we had come since our first report in 2003. Under suspicion, our research and consultation report took another look at the lived experience of racial profiling in Ontario. Our goal was to show that despite a so-called end to street checks, racial profiling continued to harm the dignity of many Ontarians and to provide guidance to prevent and combat it. Under Suspicion reflected the experiences and voices of well over 1,600 individuals and organizations in Ontario. It presented a snapshot of lived experience and the personal impact of racial profiling, and it also provided important insights into possible solutions. As we worked through our consultation and looked at the research, a few key themes emerged. For example, our research found that racial profiling was a pervasive and everyday reality for many Ontarians. Racial profiling is systemic in nature. It happens not necessarily because of individual biases, but because of organizational policies, procedures, and decision-making practices, and is often deeply rooted in the organizational culture. Another theme was the significant harm that racial profiling causes to individuals, families, and the social fabric of our community. A prominent civil rights lawyer in Ontario, Anthony Morgan, says it best.
For African Canadians, racial profiling is about Black men living constantly under suspicion of being gunmen, robbers, drug dealers, gang members, pimps, sexual predators, or known to police. For African Canadian women, racial profiling is about Black women living constantly under suspicion of being shoplifters, drug abusers, sex workers, child abusers, welfare queens. Racial profiling relies on insidious stereotypes that treat Black skin as a proxy for criminality. It leads police, store clerks, teachers and principals, transport officers, private security, children's aid workers, and social welfare administrators to put African Canadians under disproportionate scrutiny, investigation, and subject them to harsher treatment. Racial profiling puts African Canadians under suspicion for simply living while Black. It robs us of our individual identities. It permits black skin to be perceived as the opposite of innocent. It justifies black skin being seen as a symbol of danger or a threat. It treats black skin as if it is a crime. Racial profiling is related to why across Ontario cities we're seeing that African Canadians are dramatically overrepresented in instances of carding. Racial profiling is connected to why African Canadians make up just 3% of the overall population of Canada, but almost 10% of our federal prison population, and are similarly overrepresented in our provincial institutions. Racial profiling is connected to why we see many of our African Canadian young people who are overrepresented within child welfare agencies across this province. Racial profiling is also connected to why we have so many black students who are streamed to fail. Students who find themselves overrepresented in instances of suspension and expulsion in our schools across the province. Though the black community has been talking and working tirelessly to address this problem for decades, racial profiling continues to be a very serious issue within our communities. And the impacts are not just individual, the impacts are also systemic, and they're felt throughout. The criminalization of black people through racial profiling causes individual victims to, as was said before and as outlined in the report, experience feelings of embarrassment, disappointment, anger, powerlessness, helplessness, diminished sense of self-esteem and self-worth. Racial profiling also triggers distrust in police, a lack of confidence and faith within our criminal justice system and government institutions writ large. Individuals' very sense of belonging, their sense of security and well-being is fundamentally eroded by the practice of racial profiling. The Ontario Human Rights Commission's report provides timely, practical, and accessible update to what we have learned about racial profiling and outlines many positive steps on how to address it. The report effectively outlines the nature, types, impact, and negative outcomes of racial profiling and provides a valuable contribution to this work. The report is critically important because it provides a comprehensive overview and explanation of the multiple manifestations of racial profiling, going beyond the policing and criminal justice sector, but seeing it as has been articulated within child welfare, education, transportation. With this report, we have now new data and analysis that reminds us once again that racial profiling is illegal, that it is discriminatory, and that it is not effective, and that it has never proven itself to be effective. If there's anything it's proven itself effective to be, it's able to simply rip at the fabric of our multicultural mosaic. To close my comments, I end with a quote from Justice Harriet Sachs of the Ontario Superior Court. In a recent landmark decision of the Divisional Court, Justice Sachs awarded the highest amount of damages that's ever been awarded in a racial profiling case. In speaking to racial profiling, she says this, quote, "It has led to distrust and injustice. It must stop." Simply put, it has led to distrust and injustice. It must stop.
In Under Suspicion, the Commission made several commitments. Amongst other things, we committed to collaborate with First Nations, Métis, and Inuit communities and groups to better understand the Indigenous perspective on racial profiling. We committed to develop specific policy guidance on understanding and preventing racial profiling for law enforcement, police agencies, child welfare, courts, and correctional authorities. We continued to call for human rights-based data collection, and we committed to work in partnership with affected communities. We also made a commitment to launch public interest inquiries, intervene in, or launch cases before the Human Rights Tribunal of Ontario to actively challenge cases of alleged racial profiling with a focus on combating racial profiling in the criminal justice system. And we're already taking some of these steps. In November 2017, we announced a public interest inquiry into racial profiling and racial discrimination by the Toronto Police Service. The Toronto Police Service is the largest policing agency in Canada, with an annual budget exceeding 1 billion Canadian dollars, and policing one of the most diverse cities in the world. We called this our Truth Before Trust inquiry. In the past, we had focused on bringing the lived experience of community members into focus and showing the harmful impact of racism. This should have been enough, but it wasn't. So in the Toronto Police Service inquiry, we are taking the next step of marrying this lived experience with hard data. We've called upon the Toronto Police Service and related agencies to provide us with a wide range of data. And we plan to marry this data with the lived experience of individuals in the community. We will use this quantitative data to pinpoint where racial disparities exist, so we can better understand the interactions between civilians and police that may raise systemic human rights concerns. We can evaluate the effectiveness of past efforts to combat racial bias, including things like training and policy changes. We'll propose targeted solutions that speak to modern operational realities, and will allow for better tracking of performance and internal accountability when racial profiling and discrimination is alleged to have occurred. We're well into analyzing case information we received related to police interactions that result in serious injury or death, and the many individual accounts that we have heard, and we're planning to release an interim report on our progress in December. We have used several different approaches in our work to eradicate racial profiling. First and foremost, we have consulted extensively with affected communities and reported on their lived experience of racial profiling. This is really the hallmark of all of our work at the Commission. After all, we can't effectively advocate for people's rights if we don't know where and how their rights are being denied. It's our job to put people and their lived experiences at the very center of our work. The second approach is to collect human rights-based data to show disparities in areas where racial profiling may be at play. Collecting this data can help us to pinpoint the problems and gauge our progress in addressing them. But the fact is, quantitative data rarely illuminates the causal factors that result in disparity and often can be easily ignored. That is why we must interpret this quantitative data in a way that is consistent with the qualitative data, that is, the lived experience. In the Ottawa Police Services case I spoke of earlier, the police response was that the data did not prove racial profiling. So it's vital that we interpret the data in the context of the lived experience that led to its collection in the first place. In Canada, data analysis must also take into account the historic relationship between police and racialized and Indigenous communities. So we need to combine the first two approaches and have personal recounts that back up the data. And then we need to make sure that the data is interpreted by communities with lived experience and that they play a central role in developing solutions. Another important approach is to always step beyond showing that racial profiling exists and to put in mechanisms to hold police accountable when it occurs. There are many different ways to do this, such as making human rights and racial profiling required elements of police training, strengthening legislation to require public reporting of race and human rights-based data related to policing, requiring police services to impose discipline when they find racial profiling has occurred, increasing the expectation that police oversight agencies investigate racial profiling and providing them with the tools to impose sanctions. And finally, setting up courts and tribunals with specialized expertise in racial discrimination issues. These are just a few of the many options, but the bottom line is that none of our work will succeed unless the public demands that police are held accountable for racial profiling at an organizational and individual level. In courts and tribunals and in submissions to provincial and federal governments, we have put forward many different remedies for tackling racial profiling. Many of these were included in our recommendations in 2016 to the Ontario government's review of policing legislation. This was the first time in a generation, 25 years, that the government looked at the legislation governing policing in Ontario, the Police Services Act. We recommended such steps as setting clear guidelines on when and how police stop and question people, including creating an appropriate framework for notifying people of their rights, prohibiting conducting immigration status checks on victims, witnesses, or individuals under investigation, unless there are credible, non-discriminatory, and bona fide reasons for doing so. And finally, requiring independent, arm's-length public monitoring of police services and police services boards related to systemic discrimination. This can be done through periodic audits, inspection of policies, procedures, training, databases, and records, and through public reporting. We also called on the government to require police services to establish permanent data collection and retention systems, to record human rights-based data on all stops of civilians, use of force incidents, and interactions where officers ask about immigration status. And we proposed an independent study to publicly report on the feasibility of requiring all uniformed officers to be equipped with body-worn cameras. We called on police services to review body-worn camera video and human rights-based data and to discipline officers up to and including dismissal when their behavior is consistent with racial profiling or discriminatory use of force. And we called on police boards to use human rights-based data to measure and evaluate police service performance on racial profiling and discriminatory use of force, and to take corrective action where appropriate. Earlier this year, the provincial legislature passed the Safer Ontario Act, which embodies many of the principles and remedies that the Ontario Human Rights Commission called for. This act will make compliance with the Canadian Charter of Rights and Freedoms and Ontario's Human Rights Code a defining principle of policing. The act will require regular diversity training, community engagement, and greater representation of historically marginalized people. It will clarify the role of police boards and increase the transparency, independence, and authority of police oversight bodies. Finally, in the spirit of reconciliation with Indigenous peoples, it recognizes the unique history, experiences, and needs of First Nations communities. This act, along with the regulations mandating demographic data collection, has the potential to transform the legal foundation of policing in Ontario. And it sends a strong signal that change is required to rebuild trust with the communities most affected by criminalization in Ontario and in Canada, Black and Indigenous communities, and people living with mental health disabilities and addictions. More fundamentally, the Safer Ontario Act shows that when government works closely with communities and stakeholders to develop legislative reforms, it can create a solid foundation to rebuild trust in public institutions. I do note, however, that the new Ontario government has paused implementation on some parts of this legislation, and we continue to monitor its progress closely. Our work to eradicate racial profiling has been very well received by individuals and organizations in the communities that are most affected. I'm proud of our ability and willingness to amplify what the community has been saying for decades. And I'm proud of the powerful alliance the Commission is building with affected communities. One good example was the community support for our recommendations on policing reform that I spoke about earlier. More than 20 community organizations endorsed our submission, and we continue to work with them on criminal justice issues. The community has also supported and worked closely with the Ontario Human Rights Commission on our work to end street checks or carding, and in our consultations and inquiries into racial profiling. While we have moved beyond the situation where most police officers and organizations deny that racial profiling even exists, we are nowhere close to where we want to be yet. Many police officers and organizations now acknowledge that racial profiling sometimes happens. In 2010, the Ontario Association of Chiefs of Police passed a resolution acknowledging that racial bias exists in Ontario and that, quote, members of police services can be susceptible to its pernicious influence, end quote. As well, the Ontario Association of Police Services Boards substantially supported the transformation of policing envisioned in the Safer Ontario Act. At the same time, however, many police leaders and organizations, including police associations, continue to question the nature, degree, and extent of racial profiling within their police services, even though people in racialized and Indigenous communities have been reporting it for years. They tend to suggest that racial profiling is the result of the actions of a few bad apples, rather than a systemic concern that demands an organizational response. So it's clear, we have made significant progress, but there is still a lot more work to do. One of the most important lessons we learned is that we have the most power when we work closely with community and amplify their concerns. This work has to be built on a foundation of trust. Just as policing can only be effective if it has the trust of the community, the Ontario Human Rights Commission needs to continue to take whatever steps we can to build and maintain the trust of the community. A key part is being seen as an independent human rights institution that puts people at the center of our operations. We have learned the value of collecting human rights-based data along with qualitative data related to lived experience. Only by combining qualitative and quantitative data can we present the most compelling picture of racial profiling, a picture that can't be ignored. And only through this combination can we pinpoint where the problems lie and take concrete steps to resolve them. And finally, we have learned that only by working together with the community, the police, and the government can we create an Ontario where the next generation can thrive instead of being under suspicion for no reason other than the color of their skin. Thank you.